You should see it soon.
Hey, here we are. I think we are live. Hello, hello.
Hi, Kristen.
Hi. Hi, Jack.
Raring to go.
As you know, David and Sam are off learning new things this week. So I am here, Kristen from Carolina Retirement Planners, and we have Dick Horgan here, attorney at law with many specialties. But today we're what are we talking about, Dick?
Any question the folks have about trust and estates or estate planning, pretty much sky's the limit.
Fabulous. We're gonna hit plenty of those today. And as always, we have behind our scenes here, Miss Amy.
Hello.
Hi.
Hi, how are you guys?
Okay.
We're getting a little wild while the bosses are away. So
We are. But I know that we have a lot of questions, so we should just say cheers, say happy National Cheese Toast Day, because that's today. And yeah, cheers.
cheers
My
to
fancy
that.
You don't have where's your fancy beverage?
I was in the mood for a little sugar boost.
Okay.
A nice classic Coca-Cola is never a bad thing.
I'm drinking a peach Moscato. It's a light peach Moscato. It's not sweet, which is surprising.
Oh.
Yeah, I thought, it's from Aldi. I've had it once before on the show, but yeah. Dick, what are you having?
I'm a lot older than the two of you added up, so I'm having a scotch and water.
That's not a bad drink either, but I have stuff to do afterwards. But yes. So and like I said, happy National Cheese Toast Day.
Cheese Toast Day.
Yeah, Cheese Toast Day, Grilled Cheese Day.
Quick fact for you.
Yeah.
National Grilled Cheese Day is in April.
Oh, well, that's fancy too.
This is specific to cheese toast.
I like my grilled cheese with tomato soup. And with that, I'm going to go over here and work. And I know we have a lot of questions, so you guys can discuss your favorite cheeses and sandwiches and things. But
all right, thank you, ma'am.
Bye.
You got one of your favorite cheeses, Dick, before we get into the hard questions?
Pretty much any cheese is a good cheese.
That's a fair point. All right. I know we've done this once or twice in the past, so we're going to get right in there. One of our regulars sent us a couple of questions that I'm going to hit you with. First off, generally speaking, should a couple have their trusts or have their checking account in their trust? Is that worth putting in there?
In one word, the answer is yes. It's not required because typically a married couple with a household checking account to pay the electric bill and stuff will have both names on the account. They'll be co-owners and they'll have checked the survivorship. There'll be joint tenants with right of survivors. So hubby dies, wife owns it, no paperwork, etc. Wife dies, hubby owns it. So they can leave it if they want to with just the two of them on the title to the account, etc. It's better to put it in the trust for a variety of reasons that would include if one of them had a stroke, became disabled, if they both, and it's not going to happen statistically, but if they both died in a car crash or a tornado, you're going to have two probate accounts, two probate estates for half the value of the thing. So there's several reasons why it makes sense, and it's easy to do. Banks will put a given checking account, money market, savings account, same with credit unions, into a trust. Wham, bam, thank you, ma'am. Not hard to do.
Okay. I think that makes sense. It's going in the trust. You got it. Another good question here. Do you foresee any legal changes coming up in the coming years, like sunsetting or things that have protected assets in the past, and may anything coming up that you foresee?
That's the scariest question on the list I've been given a couple hours. Because our good friends Biden-Harris administration are talking about making a whole bunch of changes that would, I'm not trying to scare people, would dramatically change the landscape. There's talk about doing away with the exclusion for a single person or married couple on capital gains when a residence is sold. There's talk about significantly reducing the estate tax exemption. There's the biggest issue, I suppose, of all, is there's a lot of noise being made from the Democrats that they would like to, that they're considering ways to eliminate or drastically reduce the step up in basis. So if there's a real estate that's appreciated or stock that's gone from 50 to 100, the heirs, the children, let's say, or the surviving spouse will inherit it at the fair market value of date of death. The historic IRS cost basis gets stepped up to the date of death value. They're talking about taking that away. That would raise a tremendous amount of money for these idiots in Washington to then be able to spend. So they love that. But I don't think that, we got a lame duck president for the foreseeability, for the foreseeable time. We've got an election coming up that may well change things quite a bit. So I don't see any of those major changes happening, but there are a lot of progressives that want to see them happen. I mean, they're trying to restructure the economic landscape of the country, and they're going to use some of the tax laws to try and do it, but I don't think it's going to pass. But you can go to Forbes or one of the big publishers on financial stuff and look into on the internet, what the various proposals are for, just call it tax reform, because that's how they're labeled. It sure as hell ain't tax reform. They want to raise taxes by screwing around with the present exemptions and the like. So there are a lot of changes in the wind, but I don't think they're going to happen.
Wow, I didn't realize I was asking you such a big question. I'm glad we went over that.
Me too.
A lot of information.
That was.
Well, perfect. One of our guests here, they asked some good questions to get us some good information. Now, something a little easier, I think. We had a question sent in that says, if we got a estate plan done in North Carolina, and they subsequently moved to another state, say Maine, maybe, is the estate plan still valid then in Maine?
Short answer is yes. Today, all states recognize as valid a document done in the prior state where somebody lived, assuming it was validly executed at the time. So a will or a trust or a power of attorney validly done in North Carolina, and this couple asked about Maine, I think, would be valid in Maine. The only two, so they're portable to another state, okay? They're going to be valid, et cetera. The one sensible exception to that is that each state has their own form of healthcare power of attorney and living will, and they're quite state specific. And we don't use coma. We don't use persistent vegetative state language in North Carolina. A bunch of states do. And so when you move to the new state, the nurse up there is not going to be familiar with how 49 other states deal with it. So it makes sense when you relocate to, and there's simple forms available on the internet. Your doctor in Maine, in this particular couple, could give it to you. So a new living will and a new healthcare power of attorney are very easy, not expensive. But those are the only two that, although they're in theory portable, as a practical matter, you should have the form of the state where you're now residing.
Okay. Now, on that same kind of waves there, when somebody then has to go in and make some adjustments to their trust or their estate documents, is how involved is that? Is that something that it's easier or something that they need to do? And is that something that you offer?
Yes to the last point. I mean, I obviously have to update. I mean, why wouldn't I? And they need help. But no, the real issue is this. We all know the expression different strokes for different folks. Well, different statutes govern different documents. If you're going to do a healthcare power of attorney, you got it in North Carolina, you have 2 witnesses and a notary. It's not valid if you don't. Comes to a trust, that's not required. So the formalities required to make a change in a document depends on what type of document it is, okay? You can actually make a change in a will or in a trust 100% in your own handwriting, no notary, no witnesses, no lawyer involvement. So the hypothetical I always give is one couple wrote in their trust, that 5 years ago, they want to leave $2,500 to church A. They've now switched churches. So all they gotta do is sit down and say, this is amendment number 1 to our trust dated such and such. Please do it legibly so your kids can read it. But amendment number 1 to our trust dated such and such, on page 12, delete the Presbyterian Church, replace it with the Lutheran Church on 123 Main Street, and change the amount if you want, and sign it and date it. You've amended your trust. So one minor advantage of a trust, revocable living trust, is that they're very easily amended. But you go to do a living will, they want 2 witnesses and a notary if you're going to make a substantive change. And one more thought, a substantive change is not the fact that your kid moved from this street address to that. Okay. You don't have to update documents because they're still your kids. They still identify by name. And so you don't really need to keep your documents updated with addresses. But on the healthcare power of attorney, your healthcare provider, the doctor and your healthcare providers should have the current cell phone numbers of all your healthcare agents. They're not going to send a letter when you're in a car accident. They're going to pick up a phone and try and call your daughter. So they got to have her current cell phone number.
That's good to know. It's good to know. I think that we had a couple of people send that one in, so we're addressing a little bit of everything.
If it's a complicated amendment, you might need some help. But a lot of amendments are quite simple, and I find myself dictating them over the phone to a client. Easy to do.
Okay. Now when people are looking at getting a trust, maybe for the first time, or looking at making changes to a trust that is done, and they're looking for an attorney that can do that for them, what should they be looking out for? What's some good things that you want out of somebody that can do that for you?
You're talking about evaluating the attorney or talking about the document itself?
Like how would you pick a good person to make your trust? Like what makes,
Well,
I guess, more evaluating the attorney?
how do you pick a spouse? Who the hell knows? How do you pick your sister? Who knows?
That's a good question.
So, basically, what you do not, I mean, the bar associations in every state has referral programs, et cetera. But the point, I think, the way I answer that question without being cavalier about it is that the era of specialization is here. The jack of all trades is long gone. If you're going to do an estate plan or changes, you do not want to go to a lawyer who does divorces on Monday, immigration issues on Tuesday, plays golf on Wednesday, does real estate on Thursday, and once in a while on a Friday afternoon works on a trust. You want to find someone whose practice concentrates in trusts, and word of mouth is a great way to do it. I would not look at the billboards driving down Oleander for Mako the Shark legal. Okay, I don't think that's a great way to pick a lawyer. So word of mouth of people who've done.
I think that's a more than fair point. I think I've only used billboards for picking my food, so.
Okay.
Oh, it looks like we might have some technical difficulties here.
Can you read the next question, or shall I?
I think we're okay. I don't see anything. Do you see difficulties?
I was, had you guys frozen there for a second.
Oh,
I couldn't hear
okay.
anything.
Oh, no, maybe you, I'm watching on Facebook and I see Dick fine. Are you freezing?
Everything looks okay over here.
And
Okay.
Kristen, go with your next question.
Yes.
Okay, I think we're back. Another question that we have here is, do you know of anything that's specific to widows, maybe women specifically, to have prepared in the instance of their husband's sudden death? Is there anything like particular that should be done that you can think of?
Well, okay. The stereotype of hubby and wife going back to our parents' age was dad run the show, mom did the cooking and raise the kids. So mom didn't know about finances when dad died. That's something to be avoided. These days, women are playing, I'm stating the obvious, women are playing, wives and mothers are playing a much more active, proactive role in household finances and knowing what dad's IRA is and that it's at Fidelity and so forth. So at a minimum, there should be a list of the assets and the contact people so that the surviving spouse will know that the spouse who just died, maybe overnight in a heart attack tragedy, had 3 IRAs, not one, or had a, you know, now most couples know what each other have, but it's very helpful to have that stuff in writing. And I put in my trust binders places where people can put what their assets are, because your adult children are not going to know what you have. If you have a timeshare in Aruba, may not know that. Okay. Yeah, presumably, if you have 2 cars, they'll know that, but it's just useful to list the assets. It just makes sense so that the likely survivor, which is each spouse, and the adult child, certainly the 1 or 2 you're going to put in charge, they should know what the game plan is and what the major assets are, and importantly, where to find the documents. Now, if you guys die with a home safe with no combination, they're spending $135 on a locksmith to break into it. Now, that shouldn't happen. So you should find ways to make sure that the people who will implement your plan know what's there, what the game plan is, have access to a copy of your will, your trust, et cetera, et cetera.
Okay, that makes sense. Don't be hiding those documents too out of reach.
See, that's not the law, that's just common sense.
Right. All right. And I know we've talked about what to do with the trust, but maybe for somebody like me and that may not know a whole lot about trust in general, like what is the benefit of a irrevocable trust versus a revocable one?
That's really not the question you should be answering. I'll answer it, but there's a better question that comes up all the time. Irrevocable means it's in concrete, it cannot be amended. Revocable or revocable, depending on how you want to say it, means that it can be amended while you're alive. I rarely do an irrevocable trust for someone that cannot be amended. The horse is out of the barn, you ain't getting it back, you've lost the value of it, and it's gonzo. You can't, and we can't predict the future. Flexibility is important. So virtually everything I do, I always tell my clients that every damn document we're doing is going to be changeable in 5 weeks, 5 months, or 5 years. They're not painting themselves in any corner. So there's a huge difference between revocable and irrevocable. Once your standard probate avoidance trust, your standard revocable living trust, once the author dies, it becomes non-amendable, irrevocable, just like dad's will. Dad can change his will. When dad dies, his will is now irrevocable. So that's that difference. The question I thought you were going to do, which is one of the ones that was sent, is to just summarize a trust versus a will. Why would one bother using a trust instead of a will?
Yes, yeah.
That's the key question that's sort of fundamental to my practice, because 95% of my clients use trust because I make that recommendation to it. Okay. Several things to say. I'll do it real simply. Number one, the hidden cost of a will is the fact that for the will to have any effect at all, you have to run the assets under the will, through the will, meaning through probate. So that whatever the negatives are of probate, the main one being expense and delay, that's going to impact all those assets. So, and people don't realize that your beneficiary designations on the 5 major types of financial assets, life insurance, annuities, brokerage accounts, bank accounts, and what else is out there, and retirement accounts, those are going to pass by beneficiary designation. Now, you may name your trust as a beneficiary, but most people name human beings. So they're going to be received by your beneficiaries outside of the trust. But the hidden cost of a will is you got to run the asset. For the will to even apply to an asset, it's going to go through the probate process. So that's a big deal. The other thing is when you use beneficiary designations to minimize probate, and I say this all the time, in my view, a beneficiary designation is a poor planning tool because all it says is who gets it. Not even a sentence about whoever it is, just their identity. So it doesn't allow you to do any planning. And the two types of planning that most of my clients would like to do is to have some control or ability to control what the beneficiary does with the asset. And more importantly, they want to protect their adult child, son or daughter from divorce, creditors, and estate planning and taxes. So you can't do that with beneficiary designations. They're simple, they're inexpensive, and they just say who gets it, but there's no real planning involved. And so the point is, another real quick way to say it is, a will has bad news and good news. In my view, a trust has good news and good news. With a will, the bad news is you're taking the assets through probate, and that's going to be a hassle and expense. But you can plan. With a trust, you avoid probate and you can plan. So you got two good things with a trust and only
Absolutely.
and a bad thing with a will. That's the difference. A lot more to say, but with time.
That's the heads and tails of it, though. Well, I feel like I had no idea. I thought a will was just the way that it went, and it turns out things are a little different than.
There's so much. It's actually very complicated. And that's why we have Dick, because
Yes,
absolutely.
we are glad that he is here.
Let me thank you. Let me inject one simple example. All the time, people don't take this wrongly. All the time, I meet a widow, and she's in her 60s or 70s, sometimes 80s, and she got this beautiful will. It was done with a lot of care. She paid a lot of money for it, and she's assuming that the will will govern all her assets. Well, it ain't so, because the life insurance has a beneficiary designation, won't be under the will. Ditto the brokerage account, ditto the bank account, ditto the IRA, 401k. So you've got to look at each document and each asset and say, where is it going to go when I die? And a lot of them are going to be governed by beneficiary designations, unless you, while you're alive, you retitle the asset into the trust, or you name the trust as the beneficiary. Then it will come under the jurisdiction, so to speak, of the trust, be governed by the trust. Otherwise, there's going to be a check in the mail to the beneficiary, and you have no ability to have any say as to what happens.
That's no bueno. Not good.
No, I
I mean,
feel
we definitely need a trust. Yeah, it sounds, I mean, that's
Well,
definitely.
In a lot of cases, it makes sense. You can't jump to the conclusion you need a trust because, for example, if a couple has two adult children and they're both level-headed and sensible, and there's a modest amount of assets involved, then just let the kids inherit it. You know, if a child's going to inherit 111,000, three kids are going to inherit 111,000 each. That's a nice chunk, but it's not huge. And they may not want to spend the money. If the kids are level-headed, they're in good shape. Just name them the beneficiary, and then the grandchildren with as contingent beneficiaries with careful language. So it's not a one-size-fits-all. I do not recommend a trust for everybody.
Okay, with that, I have a question for you. It's not mine. Bruce has asked, what happens to a trust when the attorney retires? What happens then?
That's a good question.
What happens to your? Yeah, okay. The answer is nothing happens to the trust when the attorney dies.
I like it.
I mean, a lot of people, let me start it different. This is going to be lawyer bashing, so the crowd will like this. Okay. I love it. A lot of lawyers keep the original in their vault for safekeeping. That's what they tell the client. They're really doing it for two reasons. It's true that the attorney's vault is safer than your home safe or your desk at home. So safekeeping is a legitimate reason, but the real reason they're doing it is so the adult child or the widow will have to come and get the original and sit down with them and sell them some more legal services. They want the client to be captive. You have to go back and get it. Okay.
Oh, snap.
They have the right to get it for free with a phone call or a letter, but they don't know that. So they don't sit down and the lawyer then sells them a bill of goods. But
a little behind the curtain action there.
It's like hang on, you got a deed to your residence prepared by attorney Joe Blow. If he dies, you still own the house, you still have the deed. No effect whatsoever on a trust or a will or anything when the attorney who prepared it dies. It means you might have to go to somebody else if you want to ask questions about it, obviously, but there's no impact whatsoever on the document.
Wow, that's good to know. Thank you. Yeah, that's definitely good.
It's very important because I'm 79. I ain't going to be around long.
Well, yes.
Well, you're gonna be a long, you have a, you're gonna be a, no, you're gonna be here for a long, long time. Disagree with that.
Yeah, you can't retire. We've got lots more questions.
Your mouth to God's ears. Okay, what's next?
All right. It kind of comes back to
There's
something we touched on
one,
earlier.
yeah, well, there's one, that came in on Facebook, and I don't know if you want to address it if we have time or not. But Kim has asked, what are like some of the pitfalls of using a do-it-yourself trust software? Is there anything
Ooh.
that you could think of?
How
I
long-
personally find that they don't ask me the proper questions, but I want to see, I mean, this is from Kim, and how you feel.
How long do I have to answer this question? There are a lot of pitfalls. You don't want me to go fix your engine when your car conks out. Okay. What the hell do I know about a car engine? Zilch. Okay. So the do-it-yourself, what happens is the software, they're generic. They're in the sense of written to apply to all the states. So when you can use them in Tennessee, you can use them in Montana. They tend to be a one size fits all. They do not allow of any true customization. Yeah, 3 kids, 1/3 each, but you can't go on and say you can't people care about their kids. People care whether a kid drinks too much or spends too much money or has a spouse they don't like. People care about their grandchildren intensely. So when you talk with people, which is what I love to do, talk with people about their family, they have things to say. And grandma cares about that 11-year-old granddaughter. She really does. And she would like to know how to protect that granddaughter. You do not want a granddaughter inheriting $189,000 at age 18. They're going to be in Fort Lauderdale 2 weeks later in a Mustang convertible. They won't finish college and they walk away from their job.
Absolutely. That's what I would have done.
That's a very good point.
No, so your standard software says, sure, 3 kids, 1/3 each. And if one, God forbid, one adult child dies, it goes to the 2 kids in that family. Well, what if the kids are 11 and 13? These would be your grandchildren. Well, you can have a court-appointed trustee with a bond requirement and fees until the kid becomes 18 or 19, depending on the state. Then they get the money and they buy their first Porsche, which may not be the right investment for the kids. So generic software things. I mean, it's like, are you really going to go to Home Depot and buy plans for a house and then build your house? If so, you're nuts. Because you won't get the house you want, it won't get done, and the damn thing will leak. It's that simple.
I agree. My father-in-law is an architect, so I agree with you 100% on that analogy.
Yeah. No, I don't think I would. I'll leave it to the professionals. I think that's what we're getting here. We're leaving it to very specific, smart individuals like Dick here.
Kristen and Amy, I know we're limited on time, so here's what I would like to do. I'm going to try and call tomorrow or over the weekend. There's some questions we didn't get to, okay? I mean, there are a bunch of them. And some are very client specific. I mean, they're not that.
I noticed there was some real specific situations there.
So you favor their phone numbers. So it's so easy for me. I'm going to call these folks and chat with them about their question and the answer. Okay. Because we can't get to everything today. I mean, some of the questions are really quite client specific, easy for me to answer, but we can't get to it today because it's a half an hour and we just can't get to them.
We've got
You're the best. We
Yeah.
love you, Dick. You're the best.
Absolutely.
It's
Thank
easy.
you for doing that. I'm sure people will love to be hearing from you.
Right. And I also put in the Facebook comments about how they can reach out and send Mary an email to schedule just a quick one-on-one with you. Also, if we didn't get to that as well.
Which can be phone or Zoom or face-to-face.
Perfect.
See, that's even better than what I said. I just said it was going to be a phone call. Look at you. Aww.
Zoom is so easy these days, and COVID required it to be easy. So it works pretty well.
Yeah, it taught us all how to make sure that, to use a filter so we don't look so crazy.
I have a 94-year-old terrific lady a widow, 94 years old. She loves Zoom. I mean, so it's not that hard
Zoom
to do.
is great.
remember when Skype was a thing. And I'm so glad
Yeah.
we've progressed.
Yeah, we're technically Zooming right now.
Perfect.
And
Okay.
I have to put this in here only because my mom and my grandson are currently watching. And
Oh,
yeah, my grandson
hi,
wanted to say
guys.
hi. Yeah, so yeah, my grandson Declan says hello. So yes, I am very protective of him. So you're absolutely right, Dick. I would do anything for that little man.
That's what happens with life. You know,
Here's what happened.
people become more important than things as you get older.
They do. And with that, I think we have something to fun to do, right? Is that right, Kristen?
Yes, yes, we're bringing the fun times. It's always my favorite. It's definitely Sam's favorite each week. After we learn, of course. But we have our wine drawing. All right. Got lots of entries this week.
You really did.
Lots of questions for Dick. Lots of favorite cheeses. And our winner is Debbie and Jean S.
Woo! Here's where I pop out. It's like, congratulations! Yay!
Congratulations, you guys.
Yes, thank you.
So what do they get, Kristen?
They've yeah.
Well, the details, I said a wine drawing, but for different ways that you can enter, RSVPing on Facebook, answering Amy's questions, giving us some new topics, entering questions to Dick. Each of those got an entry into our wine drawing this week and something similar in other weeks. And you win 2 bottles shipped directly to your door from Fermental.
We love Fermental.
Absolutely, we do.
Yeah.
So excited for their place to go visit their new place.
I have to get there. I haven't done that yet. So I will. I keep saying I'm going to make it, but I haven't. That's going to happen. We've been busy. And we do not have a topic for next week, but David and Sam, they return from their conference in Dallas, and I'm sure they're going to have so much fun information. It's going to be crazy. So
And they'll be a lot smarter after a few days in Texas, I'm sure.
always. You're absolutely correct. Absolutely.
Yeah, we'll be back to our regularly scheduled programming.
Yeah, but then we'll miss you. So, and of course, we will definitely have you back on. So you are a fan favorite, Dick. You really are. You're my favorite. So I love when we have you on. Yeah, you're my favorite. You're my favorite little, special guest host. So
Flattery will get you nowhere, Amy.
well, I have no. I mean,
Get you everywhere.
What do I need to get? I don't need anything. I'm good. I'm being honest here. So yeah.
All right, so we're in for a nice surprise episode next week.
We are.
And anything else, Amy, or
No.
cheers to that, huh?
I'm going to start now and march through phone calls to some of these clients.
You're wonderful.
All right.
You're so great.
You're waiting by the phone.
Yes. Thank you. Thanks, Dick, for your time. And thanks, Kristen, for your help. So
Thank you.
we appreciate it. We'll see everyone next week. Oh, yeah.
Cheers.
Cheers. Take care. Bye-bye.